I hope you are excited as I am. And the way the program will work is we will begin with the panelists who will provide brief breakdown on different discussion questions on social economic rights. And then I'll open the floor to the listeners to ask questions. And we'll finally have the concluding statements by the panelists themselves. Having mentioned this, allow me to invite the first panelist, who will be Dr. Victoria Miandazi. Dr. Victoria Miandazi will give an overview of the social economic rights in the context of Kenya, but to her, and she will have 15 minutes to provide feedback on the said questions. So, Dr. Victoria Miandazi, you're welcome. And for the questions, my first question will be, how have the courts in Kenya adjudicated on the justiciability of social economic rights? Additionally, what roles do the state and non-state actors play towards the realization of social economic rights, keeping in mind the concept of progressive realization that enhances the resource-dependent argument that global South states have been seen to rely on? And lastly, would you recommend the practice of collaborative constitutionalism to ensure the fulfillment of the state's promise to Kenyan citizens? Dr. Victoria Miandazi, you're welcome.
Thank you, Ruth, for the introduction, and thank you to the Avid Readers Forum for the invitation. Socioeconomic rights are very important and very dear to me, just because of the impact they have in everybody's life. And so just to give a general overview and a context. So first of all, we start, where should we start? We start with a promise. And so we get to 2010. And, what transpired before then? What transpired was that there were lots of problems in the country, particularly in relation to inequalities, regional, socioeconomic regional inequalities, because obviously those who were closer to power would get more resource allocation in terms of the development, socioeconomic development, and of the various regions or now counties and provinces. But those who were more of the dissenters would not get access. And not just that, there was a problem in terms of planning. We might, it might be prudent to go back to 1963. Upon independence, there were just a few schools, secondary schools, few hospitals, and so on. So socioeconomic rights was then the main agenda, but there was a lot to do that we haven't been able to fulfill up until now. So with the 2010 constitution, there was a push, Kenya having gone through the post-election violence and there being lots of many other problems, there was a push to have a change and to have constantly entrenched socioeconomic rights. And that was basically meant to be a form of emancipation. So the law using the law as a tool for emancipation. And what do we mean by that? So the law was meant to be brought hope that things will be different. And so Article 43, for instance, the whole of it talks about the right to access to, that every person has a right to the highest attainable standard of health, first of all, including reproductive health care. Secondly, access to adequate housing and reasonable standards of sanitation. Then everyone has the right to be free from hunger and have adequate food of acceptable quality, clean and safe water of adequate quantities, social security, education. No one should be denied emergency treatment, and that the state shall provide appropriate social security to persons who are unable to support themselves and their dependents. So there was a lot of euphoria, and there was a lot of hope that people would get their rights enforced. So after the euphoria passed, then we get to the point of, okay, so how are these rights actually going to be implemented? And so there's been a huge focus, as I said, your past question is how have courts implemented these rights? So there was a huge focus on courts, could be because obviously there were also judicial reforms and people were or are usually skeptical of the government, noting that Kenya was an authoritarian government, had an authoritarian government pre-2002 and post-2002. Kenya moved to become a hybrid democracy, meaning that it's in between an authoritarianism and a more democratic state. So people were very skeptical about the government. So there's a lot of there's a lot of hope that the courts could do something. But then when we look at the initial cases, they were quite positive. Look at Kabwimwai, for instance, on access to education and particularly quotas for people who study in public schools and are transitioning to secondary schools. So there being quotas or more quotas in relation to how many slots do people from public versus private schools get. So, these first cases set the stage and set the tone for how we think about and conceptualize socioeconomic rights. So that was quite positive, but when you talk about socioeconomic rights, we have to take note of the fact that we have positive duties and negative duties. So the cases that have been successful have been on the negative duty to respect and protect, rather than the positive duty to provide and fulfill. So Kabwimwai was mainly negative, the fact that, okay, the quotas were challenged, and the court said that, in terms of providing the right to education and the problems with public education, including teacher-to-child ratio, infrastructure, and whatnot, the quotas were warranted. But then we also see, looking at recent cases, like the one for Nyaga versus Egerton University, about people being offered degrees, engineering degrees, that yet the course hasn't been fully accredited. It then becomes, it has to be about quality and actually acceptability. So when you look at the UN guidelines, for instance, the UN Committee on Economic, Social, and Cultural Rights, it provides for the three A's and a Q framework. So that is accessibility, availability, acceptability, and quality. And so we are looking at, in Kenya, we're mostly struggling with accessibility. And for instance, this recent case of Nyaga, it mainly was about acceptability and quality. We just don't accept anything. It's not just about education, but do the papers you get there actually matter at the end of the day? So we are looking at those, when we look at those cases, it's about the duty to respect and protect. But then if we look at the duty to fulfill, we'll go to cases like the Okwanda case, where Matthew Okwanda requested for medicines for diabetes mellitus at the state's expense, invoking the right to health, which also, as the UN Committee on Economic, Social, and Cultural Rights has interpreted, also involves medicines and actually social determinants of health. And not just, services. So we find that, when we think about access, about the duty to provide and fulfill, the court said that, and it was actually Justice Majanja, God rest his soul in peace, who said that, there is a problem with, with the litigation in relation to socioeconomic rights, because in that case, the judge said, if the states uses all its resources to sort out healthcare needs for people entirely, that will deplete the resources that are available to meet other rights. And so the case was dismissed for other reasons. That is, there was evidential issues that weren't sorted out. But in the obiter dicta, and if you read the judgment of the case, the judge was basically saying that, this socioeconomic rights cases and litigation can actually be used to create beneficiary inequality, because those who are able to access courts can be able to jump the queue. So then we get to wonder, does it mean, what then should be done, right? Because if it's to provide and fulfill, there are lots of challenges. But we're finding that, okay, there are some cases on providing and the obligation to provide and fulfill that have been successful. For instance, emergency medical care. There are many cases of women being in need of maternity care, and particularly initially post 2010. And so the judgments have been were able to guarantee that, or to compensate them for being turned away or being detained after giving birth for failure to not pay the fees for the hospital. And in one case, at that time, I was very privileged to be working at the Judicial Committee on Elections under Justice Majanja, and I used to go to court with him. And I remember one time he did a really fascinating thing. It was a case on failure to pay medical costs for a patient who passed away, and the hospital had refused to release the body for the family to bury. And you can just imagine how devastating it was for the family. There were so many people coming to court. And the judge said, there's a way you can handle the payment. The family is willing to give a title, just have that and everything, and release the body, and everything else can be sorted out in a legal manner. You don't have to be ruthless. And we are seeing that even in the water tribunal. There was the Congo Apartments case where the landlord failed to pay the water bills for the apartments, yet the tenants had already paid with the rent. And so the provider, the water service provider, removed the whole system because the landlord had failed to pay. So the water tribunal said that was a violation of the right to water, because cutting the water or stopping the provision of water does not mean that you remove the whole system, because it's something that can be solved. So we are seeing that there are progress in terms of cases, particularly the right to respect or obligation to respect and protect. But then there are many challenges on providing and fulfilling. And as will be discussed particularly on the right to housing, there have been innovative ways of saying, okay, if you have to evict people, you have to provide them with the alternative housing, or if it's land, you have to give them an alternative before you can even evict them. And so that then creates an avenue where you can have both the negative duty to respect and protect and the positive duty to fulfill. So we are seeing that is positive, but in one case, for instance, Gautam and Ian would talk about the Me Too Bell case. And I received a message from one of the people who live, because I've written about it. So one of the people who lived in the Me Too Bell informal settlements actually emailed me and said, you talk, everything that is said by the court is really positive, but we still haven't been able to benefit from these judgments. So there's also a problem with adherence to court orders. And do we stop there in terms of impact and looking at what the courts have done? Should we stop there and say, oh, this was progressive? Obviously, they're really good in terms of setting the tone, and in terms of they're useful in highlighting the problems that are happening in society. But then one of the things that I want to do is follow up on these cases. What happened afterwards? Because it's a good judgment, but does it really lead to positive effect and impact in the litigants' lives? And also talking about the fact that public interest litigation is helpful because it can, particularly when it doesn't just focus on those, the parties in the case, but also those in a similar situation as them, so as to avoid this beneficiary inequality that only those who can access the court then are able to get their socioeconomic rights fulfilled. So your second question is, okay, what can be done in terms of implementation? Because there's also a pandemic in the country, which is there's a lot of corruption, intransigence, incompetence, inattentiveness, as Roach and Budlander highlight. So when we think about these policies being implemented by the state, there are so many problems in terms of those aspects of implementation. And so we shouldn't let the government off, but how can we push for implementation in a more pragmatic way? So non-state actors and quasi-governmental organizations are really helpful. And I've done research on the work of the Kenya National Human Rights Commission and the National Gender and Equality Commission in terms of their role, especially on socio-economic rights issues. And from their reports and also following through on implementation, they have been successful in pinpointing aspects of in policies or legislation that are not helpful and that need to take into account Article 43, and in relation the fact that there's need to focus on those who are most marginalized and vulnerable. So that has been helpful. They've been able to also mediate between state entities and the people in getting their rights enforced. For instance, there are many reports on, or there are many focus groups that they've looked at who are being evicted, and before they're evicted, there've been discussions on getting them alternative land, and that has been seen through. So that is very positive. And so we need to see more of that, and there's a space for civil society to bridge the gap between the state and the people. So in terms of oversight, in terms of bringing people to the table. So then we find a space in terms of collaborative constitutionalism, as Aileen Kavanagh discusses. So she discusses a lot about the fact that, we see, these various state organs as villains and heroes. And now in most of the discussions on socioeconomic rights, we characterize the courts as the heroes. We want them to be the heroes, but they are incapacitated because there's only so much they can do, particularly in relation to the obligation to provide and fulfill. So there's need, in terms of this collaborative constitutionalism, there's need for, particularly civil society actors, quasi-governmental organizations, and state actors to come together. And this has to be an intentional effort, particularly by quasi-governmental organizations like the National Human Rights and Equality Commissions, because they have that, flexibility to be in between. But it could also be from civil society. One person or, one organization needs to come up and say, oh, let's work together and come up with a strategy or a framework to make sure that there is implementation is actually followed through. So there's a lot of legislation on water, on healthcare, but there isn't much on following up on implementation. So the committee, to just finalize, the Committee on Economic, Social, and Cultural Rights, as well as some of the South African cases like Grootboom talked about, the obligation not to take retrogressive measures, to have a plan, and the plan to have, to sort out urgent needs, to have midterm goals, and to have longer term goals. And so if there might be a need for legislation or to just bring together aspects of implementation and oversight by, both these quasi-governmental institutions, which are known as fourth branch institutions protecting democracy, and civil society, to provide oversight on how to ensure fulfillment. And not just that, for there to be maybe a review of some of these laws, perhaps every 2 years, because now there's a problem as well with secondary school education, or with the university education and the new funding plan. There's also a need to have a lot of public engagement, because most of these discussions are made without true, meaningful consultation with the people who are most impacted. So I have 1 minute left, so I donate that time to the rest of the speakers, and I look forward to hearing responses on that. Thank you.
Thank you, Dr. Victoria. You have provided a good foundation for our discussion today, and I like what you have said about how quasi-governmental actors can be able to be brought in so that they can provide oversight, which, as much as the judiciary describes itself to be as a repository and a watchdog in terms of the enjoyment and the fulfillment of social economic rights, they do lack the capacity. And therefore, thank you for bringing this up. I'll now let Mr. Ian I have the first is how has the abandonment of the human rights approach affected the fulfillment of social economic rights in Kenya, such as the right to housing under Article 43, 1B of the 2010 Constitution, which has been subject to recent governmental policies, including the introduction of the Affordable Housing Plan. And secondly, how has it affected the provision of the right to education, especially with the various education transition periods that the state is undergoing, which Dr. Victoria Miandazi has highlighted, that is the new curriculum for primary and secondary schools and the new funding models for universities. Mr.
Thank you so much for the introduction. Let me begin by, first of all, thanking and congratulating the Avid Reader Forum. The Avid Reader Forum has become a premier platform for public intellectual discourse. For me personally, it has offered me some refuge and a great grounding when it comes to the academy, since I transitioned fully from academy to active practice. So having said that, let me jump straight into the topic of the day. And my thesis today is on the issue of implementing socioeconomic rights in disregard of the human rights approach. And I'm looking at the two case studies, but I'll delve more into the issue of housing because of time constraints. Let me begin by saying that the implementation of most of socio-economic projects in Kenya is facing what I may call a human rights crisis. I call it a crisis deliberately because of the nature of the projects affected and the extent to which these projects have been intensely facing difficulties or hurdles to their implementation. May it be the social housing insurance fund, affordable housing program, to school funding program that they are calling variable scholarship and loan funding that has caused a lot of jitters in some quarters. And what I think, if you were to ask me, that is the root cause of all this problem is what I may call the pet projects of government. I know every leader, they are grandiose, they have their own projects that they would want to be remembered, and sometimes for their selfish reasons, perhaps maybe they want to be re-elected or not. They see that these projects are just a means to keep their legacy going in what I like to call the pursuit of legacy that you find in every leader. So everything else, human rights, how to implement the project becomes just a means that can be get rid of, that can be done away with, and it just becomes even a stumbling block to realizing these rights. So my argument today is that the situation that we are in today with the government implementation of this project, it has been caused by what I'm referring to as the abandonment of the human rights approach. Of course, I am not naive to think that human rights are the magic words to achieving an egalitarian society. I know there is also the grandiose tendency for lawyers to think their practice groups are the most important. Certainly, I'm not falling into that temptation. However, I'm making my case based on the human rights approach because it's a constitutional dictate and it's a constitutional mandate that as I shall be advancing my argument in a few minutes. Generally, there are different types of approaches that a government can take to implement the social goods or the objects of human rights. One approach that you see quite often is what I may call the economic approach, This is where the rights are looked at the objects, or they are looked at, they are treated as economic goods. If it's housing, housing is viewed as a commodity, like the way you buy, let's say, sugar in the market. So it's subject to the laws of demand and supply. And there, it means that the market, they are given a lot of leeway and say to implementation of what might seem to be social goods. And this has become even more prominent with the rise of the neoliberal economic agenda, where free markets and competition, they are viewed as values that should be elevated above common good. And the other approach is a socio-political approach. That's where, for example, when you're dealing with housing, it is viewed from the lenses of fulfillment of campaign promises. So we are going to build these houses because we're going to fulfill economic promises that were made to the people during the campaign period. And that approach, which will be the subject of my presentation today, is what I may call the human rights based approach, which focuses on conscious and the systemic enhancement of human rights in all aspects of the project and program development. This is generally a conceptual framework for the process of human development that is normative based on international human rights standards. So just to put it in layman's language, the human rights-based approach gives importance not only to the outcomes, but also the process. It says how we are going to reach or we're going to have this housing is as important as having the houses. We are not going to violate all human rights at the expense of having those houses, because the process is as important as the outcome or the result. So the human rights standards and principles that characterize this human rights approach are participation, accountability, non-discrimination and equality, empowerment, and legality. So at the core, or put differently, this human rights approach is counter-Machiavellianism in the sense that the end does not justify the means. The means is as important as the end itself. So when it comes to participation, you find that everyone has a right to participate in decisions which affect their human rights. And this participation must also be active, free, and meaningful, and give attention to the issues of accessibility. So it's not supposed to be just as a matter of formality. And the second thing perhaps to highlight is the accountability element. The projects they're required to be effectively monitored, that they comply with human rights standards, and they achieve human rights goals, and their effective remedies for human rights breaches. So this is the monitoring that's supposed to be in such projects. And the other one is non-discrimination and equality. A human rights-based approach means that all forms of discrimination in the realization of the rights must be prohibited, prevented, and eliminated. It also means that the priority should be given to people in the most marginalized or vulnerable situation who face the biggest barriers to realizing these rights. The other one that is also equally important is empowerment. The human rights approach is meant to empower people. And lastly is legality, that the human rights approach requires two things. Number one, that the law recognizes human rights and freedom as generally enforceable entitlement. And second, that the law itself is consistent with human rights principles. So, I'm going to delve a little bit to a subject just to make this discussion concrete. So a subject that all of us are well aware of, and that is the housing program, the affordable housing program that the president promulgated as soon as he came into power. And before delving into affordable housing program, first of all, it is important to look at the Affordable Housing Act, and in particular the preamble of the Act. I'll read it verbatim. So it's the Affordable Housing Act 2024, an act of parliament to give effect to Article 43 1B of the Constitution, to provide a framework and development and access to affordable housing and institutional housing and for connected purposes. A cursory look at the act, I doubt whether it deals a lot with affordable housing. It seems to be more about establishment of the fund and just administrative work. That's my critique of it. Nothing concrete, substantive here and there as you go towards the end of the act, but generally it does not seem to be per se as an act of parliament for fulfillment of Article 43. 1B seems to be more of an act of parliament for establishment of a fund. That would have been perhaps the better description of this particular act. And then let me please, you can, if I'm remaining 5 minutes or so, alert me, because I'm not very time conscious, admitted so. So let me start by perhaps looking at where does this human rights approach come from. And my argument is that Article 10 of the Constitution, which provides for national values and principles of governance, is the source of this particular human rights approach. Article 10 in particular provides that these principles of governance, they bind state officers, public officers, and all persons, whenever any of them is interpreting the Constitution, is applying and interpreting any law, and more importantly for us, they are making or implementing public policy decisions. So, and if you go to Article 10.2, you'll find one of the principles in B that is indicated as a national value and a principle of governance is human rights. So the argument here is that the human rights, which is captured in this article, deals more with the process on how we are supposed to achieve human rights, in addition to the end results. And the problem that we face today is abandonment of this process or realization of this project without regard at all for human rights. And because one may ask, why have a national value, yet human rights as an entire chapter 4 of the Constitution dedicated to it? And my view is that reading of Article 10 of the Constitution shows that the national value of human rights, they underpin the procedure of making governance decisions. And number 2, this Article 10 shows that the centrality of human rights and other principles in making governance and policy decision. I'm told that my time is almost over, but let me just delve into the affordable housing program. So my critique of the affordable housing program, to be succinct, is in fourfold. The first one is, when we abandon human rights approach, we are likely to use the housing or other human rights objects as a means as opposed to an end. And a case in example, the good example here is what I may call the capture of human rights for collateral purposes. And this has been seen with the housing program. And I want to refer to two statements, one by the president, where he was speaking to International Trade Union Congress, quote unquote, these are the president words: "I took a long time to explain what we are going to do to create job opportunities so that we can have more workers, people, and decent wages. There are three things I said I would do in my tenure: robust housing program, not because we are looking for houses, but because we want to create jobs for millions of Kenyans." So in other words, the affordable housing program is generally a cover for jobs. Not that jobs are not important at all, but human rights, when we capture human rights and use them for collateral purposes, we are likely to implement them in a manner that is oppressive and does not in any way adhere to the human rights standards, because this is just a means, it's a tool. Housing is just a tool for realizing jobs as it appears. And this has been repeated by the leader of the majority, Kimani Ichung'wah, during the debate about the bill on 15th of February 2024. He said that the bill gives us an opportunity not just to provide affordable housing, but an opportunity to create millions of jobs from engineering, architect, and so on. So in other words, there is this emphasis on jobs when we are speaking about housing. And this emphasis is not that jobs are just a collateral object or a collateral result of housing, but it appears that the jobs are the main purpose of implementing of the affordable housing program. And what we are doing is just using the housing issue as just a cover or a tool to realize this job goal. And make no mistake, I want people to have jobs, people should have jobs, but I don't think the best way to approach housing issue is by using it as a cover for jobs. And that's why you see we have gotten into these problems a lot. The other issue is that you'll find that when we abandon this human rights approach, we're going to have a contradictory government policy, because we have seen on one hand, the government is demolishing houses in Mukuru kwa Jenga, Ruben, Madare, and giving people $75 as a compensation. And on the other hand, they are touting this huge affordable housing project. You cannot speak from both sides of your mouth, approbate and reprobate at the same time, as it appears the government is doing, because clearly it shows that there's no emphasis on providing housing as a human right that is supposed to be enjoyed by people. It's just a collateral purpose item. So the other thing I wanted to, because I'm seeing that my time is really almost coming to an end, it's just to highlight the other issue of conflation of housing with of the right to house with right of the owning house. So if you look at the works of Committee on Economic and Social Right, in particular in General Comment number 3, the committee speaks of legal security of tenure in whatever forms that it may take. So that means that the government is not required to fulfill this right by building house or providing house ownership. House ownership is not the only way or the major way necessarily of realizing the right to housing. So this is just to show the conflation and the emphasis of ownership of houses generally. It just casts doubt on whether this particular program is meant to to fulfill socioeconomic rights or not. So I'll stop at that. I see my time is over, and we'll pick up the conversation as we proceed.
Thank you, Mr. Ian, and thank you for bringing out the human rights approach. I'd like to welcome Dr. Gautam.
Yeah, thank you so much, and it's always great to be back at Kabarak, in person or virtual. So I'll talk about the Mitubel case in the context of the intersection of the right to housing, landlessness, and evictions. Which has been an issue that is of considerably long vintage, and it's an issue that is, of course, stark not just in Kenya, but in many post-colonial countries that came into being marked by this kind of inequality in access to housing and to land. And to understand the context in which a case like Mitubel and this issue arises, I think it's important to go back in time to understand the origins of the problem, to understand how the problem evolved, in the course of history, and the manner in which the 2010 Constitution sought to address it, and then to understand what Mitubel does. So I'll try and go historically and then come to the judgment itself. So land and conflicts over land have been a flashpoint in settler colonial contexts from the beginning, and that this includes Kenya as well, since the formal beginnings of colonialism at the end of the 19th century. So the initial colonial period was marked by dispossession, displacement, and the capture of vast tracts of land by the British colonizers, along with the undermining and the eventual destruction of pre-colonial forms of community land tenure. So through a series of orders, ordinances, rules, and regulations, effectively, much of this land was taken over for the purposes of European settler agriculture. And along with that, the people on that land were therefore converted to either being tenants or to then having to go to urban areas, becoming the proletariat, and so on. And so therefore, land was a fundamental issue that also played a fundamental role in the struggle for freedom. And at the point at which the struggle for freedom had gained a degree of militancy at the time of the Mau Mau movement, the British responded to that demand for land by trying to create a land-owning class that would then support them against the Mau Mau. So they took various steps to do that, steps such as the famous Swinnerton Plan and things of that kind, where they tried to combine, on the one hand, mass evictions and mass displacement of the people they felt who were not loyal to them or were dangerous to them on the one hand, and along with that, to commodify land in order to create a loyalist land-owning class alongside that would blunt the revolutionary demands. So that was their policy and their strategy. And of course, ultimately, they failed, and they had to leave, and independence happened. But the land policy of the new government immediately after independence broadly matched the old policy, to the extent that instead of focusing on land redistribution and guaranteeing access to land to those who did not have it, the dominant philosophy was that of continuing with the commodification of land and, in a certain sense, engaging in land tenurial legal reform and not equitable access to land. So that then, in many ways, exacerbated and made worse the problems of landlessness and inequitable access to land that had begun in the colonial period. They then continued onwards and in some respects became worse in the post-colonial period. And this, of course, then was combined with large-scale land grabbing, an issue that the Supreme Court recently considered in more than one judgment. So a combination of evictions, of landlessness, of failing to engage in land redistribution and land grabbing combined to ensure that the land question, or the question around land, was fundamental to the movement that sought a new constitutional settlement. So, of course, on the one hand, there were questions of executive power, of curtailing the imperial presidency, and the other set of demands involved the question of land. And the two were linked in the sense that this kind of power the president had to dispose of land was in substantial part responsible for many of the more inequitable policies that came, and we can discuss that in some detail in the Q&A if needed. So in that sense, land became a fundamental issue in the process of framing the new constitution, which is reflected in the various constitutional provisions. One thing to note is that the Kenyan constitution, of course, came into being in 2010. And this year and this time is important because in the first wave of post-colonial constitution making, which, let's say, spanned from around 1940 onwards to perhaps the mid-1960s, and encompassed the independence of British colonies from in many parts of the world, India, my country, and many countries in Africa. The dominant constitutional idiom was the Westminster system and the American constitutionalism. So the idea was that the Constitution only guarantees civil and political rights. For economic redistribution, you have to go to the legislature. Now that philosophy, had been displaced by the time the second wave of constitution making happened, 1990s onwards, South African constitution and so on. And at this point, socio-economic rights as the vehicle of ensuring this kind of redistribution were what were believed to work. And so in that sense, Article 43 and its provisions follow the South African model to an extent. As Professor Guy herself has pointed out, there's a little bit of a difference in that the South African clause in the Constitution talks about the right to housing, whereas the Kenyan Constitution talks about access. And uses the word access, and there was a fear that this word would dilute the strength of the right. So with that in mind, in the second half of this presentation, keeping that in mind, I'll talk about the Mitubel case and the issues that arose in light of this long history of dispossession and land consolidation. So Mitubel arose out of a set of facts that are very common both in Kenya and elsewhere in the world, which is that because of inequitable land distribution, because of inequities in access to land, and because of a large-scale problem of landlessness, many people exist and live on land to which they do not have legal title, what in a sense we call squatters, and they survive for many years because for various reasons the local authorities might turn a blind eye. They may not do anything about it, but there comes a time often when, again for various reasons, a decision is made that these people must be put off this land. And because they don't have legal title to that land and to what they've built on it, their claim in law is weaker than that of the owner of the land or somebody who has a tenancy contract. So Mitubel was a case of that kind, where there was Mitumba village located near the Wilson Airport, home to more than 3,000 families. On September 15, 2011, through a notice published in the newspapers by the AG, the residents were given 1 week to vacate the land. They approached the High Court, which gave them a stay, but in an action that was quite reminiscent of the pre-2010 era, the state demolished their homes nonetheless. The stay having now become worthless, the residents came back to the High Court, asking for a declaration that the demolition was illegal, and consequently the state was obligated to rehabilitate them in a reasonable alternative location and grant them compensation. Of course, the issue was that the land was public land and the residents did not have legal title to it. So therefore, this village was one of the settlements whose existence can be traced back to the political economy choices that I have just discussed in the last 8-9 minutes or so, which is basically widespread landlessness and inequities in land ownership, leading to squatting and occupation for want of any other option. So in the last 5 minutes, let me look at what the case did and said and what its potential is. So at the High Court, the High Court said it found the eviction notices to be defective on both procedural and substantive grounds. It fell short of both domestic and international human rights standards. But more than that, the Constitution's commitment to public participation and centering the people required meaningful consultation before evictions, regardless of title. So here, broadly, South African jurisprudence that evolved the idea of meaningful engagement as a prerequisite to evictions was followed. And this High Court judgment was, is best read alongside the Satro's Ayuma judgment, which was a few months gap between the two. And both of these, the High Court basically drew upon comparative international jurisprudence to lay down this idea of meaningful consultation as a prerequisite to any eviction that might happen. The Court of Appeal then sets this judgment aside, on multiple grounds. I won't go into that right now. We can in Q&A if required. And the case finally goes to the Supreme Court, and the Supreme Court partially restores the High Court's judgment. It holds that you can have the remedy of structural interdicts, to address problems of this kind. You can supervise implementation, things of that kind. And importantly, on the substantive issue, the court cites Article 43, right to accessible and adequate housing, and then uses that to derive certain standards. And the court says that the right to housing is predicated upon the ability to own land, and to that we can add or to rent, or be a legal tenant. And therefore, unless you have actually title to land under land laws, you really can't mount a claim of a right to housing, even when you are being evicted. But then what the court does is that it goes on to then cite Article 61 of the Constitution and says that because under the new constitutional order, all land in Kenya belongs to the people. What follows from this is that when a landless person occupies public land and establishes a home thereon, he or she may not acquire title to the land, but they do acquire a protectable right to housing over the same. So in the sense of the prescription of the principle that all land is the people's translates into a legal interest to land that you occupy, because you need that land to establish shelter, housing, or so on. And what therefore follows from that is that this legal interest cannot be set aside arbitrarily. The state must follow these substantive and procedural principles of meaningful engagement, alternative accommodation, rehabilitation, and so on, which the court cites. That effectively is what it means in practice. So that, this is a very innovative and a creative way that the court uses to crystallize certain rights that landless people have in respect of housing, which flows from the overall idea that in this new constitutional order, all land belongs to the people. So this creation of this intermediate legal category of legal interest is what accomplishes that. So I think that is a very interesting, and it's a lot of potential there, because logically it would apply equally to private land. In the subsequent judgment, William Musembi, it is partially applied there, and so there are transformative potentials there in this idea. Though of course, in the judgment itself, you don't really have the kind of radical questioning with respect to property rights that a transformative judgment might do. So the court does stop short in a case like Mitubel it limits itself to a few procedural rights. It doesn't question the overall political economy arrangement that creates landlessness. But in this idea of all land belonging to the people and deriving from that legally enforceable interests, I would say that there is a germ of a transformative and radical possibility that future cases could develop and take forward. And how they might do so is something, of course, that we can discuss. So I have, with that, my 15 minutes are done. So I will stop and hand over to Professor Guy.
Thank you, Dr. Gautam. Thank you for giving us a good breakdown, an incredible breakdown on the 3 case laws, that is the Musembi, Mitubel, and Satros cases on how the right to housing. And allow me to usher in Dr. Jill, but before ushering in Dr. Jill, inform the audience that after Dr. Jill will be having the Q&A sessions, and therefore feel free to start asking your questions in the chat box. Yeah. And therefore to Dr. Jill, I have 2 questions. And my question is, keeping in mind that there is a phrase that in Kenya, you're always one sickness away from poverty. 14 years from the promulgation of the 2010 Constitution, what strides has Kenya taken in the provision of the right to health, especially the right to mental health, keeping in mind that September is a suicide prevention month, and also keeping in mind the concepts of minimum core obligation and progressive realization? You're welcome.
Thank you very much indeed. Sorry, I have to apologize for being, I think, less well prepared than the other speakers on this program, but I will do my best. And interestingly, when taking notes while listening to the other speakers, the first one that I've made a note to myself while listening to Dr. Mdazi was indeed related to your question. My first thought, as I wrote down, was we have a long way to go. And I began with the right to health in my notes. And I want to tell you just a small story. Over the last 2 or 3 days, a young man whom we know, who's not in Nairobi, I haven't in personal contact with him, but by phone, 2 of his siblings, I don't even know, he calls them siblings always, I don't know whether they were a boy or girl, young people, got very sick. He took them eventually to the local hospital. When they arrived, which I think was in the early hours of the morning, they were diagnosed as having cholera. The hospital said to him, go and get some money. According to him, nothing was done to those 2 young people until he came with the deposit, financial deposit, to the hospital. One of those 2 young people died. This is a classic example of emergency health treatment, right? And I mean, we would all know that cholera is something that needs to be dealt with really quickly and can easily be dealt with. It's not a huge expense. But if you don't deal with it, then fatality is all too common. How can it be that 10, 14 years after the Constitution, when every health institution ought to know that nobody is to be denied emergency health treatment, that on something as elementary as that, they should allow this young person to die? So that's, it's one of my examples of really are having a long way to go. And second one, also in the area of hospitals. This business that was touched on, I think by Dr. Mdazi, the question of hanging, not releasing people from hospital, not releasing dead bodies, not even releasing newly born babies until hospital bills are paid. I know it is a problem, but there have been court case after court case saying this is contrary, not just to the right to health, but actually to the right to liberty, Article 29. We really need to think very hard about this. Somehow we are failing, I think, to get the issues of particularly of Article 43 internalized in government and in the institutions that are required to comply with it. I fear that it's not just health. I mean, I'm not saying there have not been improvements, but it is clear that that there is a lot of serious issues particularly with the right to health. The point about the issue about no retrogressive steps, that is against Article 43, and the whole philosophy and jurisprudence and intellectual reasoning that has gone on at the level of both courts and of the Committee on Economic, Social and Cultural Rights has just not penetrated properly into our consciousness, I think, as a nation, the consciousness of lawyers, and the consciousness of the courts, and the consciousness of government. They do not take a rights-based approach. I think that's part of the trouble. It's a question of approach. If I could just add one or two other points picked from what the other speakers have said, just apart from that, again, at the moment, I don't feel able to make any sort of judgment about what the situation is going to be like when finally we unravel the legal difficulties over the replacement for the NHIF, the National Health Insurance Fund. I find it hard to understand why we have such a penchant for creating new bodies when we have existing bodies, instead of somehow trying to make the existing bodies and systems work. It must be much more expensive to start a whole new system. And we haven't internalized that as a problem. We're happily creating new bodies when there are existing bodies, creating new systems of education. Things we haven't, picking out one of the issues that, again, Dr. Miandazi mentioned, the need to plan. And yes, I think economic, social, and cultural rights are an area in which most definitely careful planning, strategizing, all the things that, if you went to do a degree course on policy, you would learn about, right? Sometimes I think we should send all our, surely that's what the Kenya School of Government is supposed to do, at least with the civil service. But we seem to be, let me be frank, pretty hopeless at this business of planning, not just in the health area, but to take, constantly half-baked ideas, which are there very often for the reasons that Ian Mwiti said, nothing to do with the benefits to the people who are entitled. In fact, the idea of entitlement just doesn't figure in government planning strategies. It's all to do with election promises, the next election, which we started fighting 5 minutes after we finished the last election. And so it's, the planning is not there. In fact, several years ago, something I couldn't find again, the Public Service Commission issued a report in which it said, one of the problems we have is that our planning is not evidence-based. And I think that's the problem. We don't start with the question of what is the problem? How do we approach it? What are the possible solutions? And let's consider all the possible solutions, and of course ask the people what they think about them, which is another thing we don't do properly. And then we get to a situation halfway through the development of something when things start to go wrong, and then they start to unravel. People start to say, go back to the beginning, if they've been saying with the new education system vis-a-vis the 844 system. It's a basic problem. I think there are a couple of other problems. I think we should be general, not just to health, but to the other issues as well. Whose responsibility is this? It would be nice to say, well, it's government, but it's, in a sense, the whole issue about the Constitution is, I think, that it's about us, about the people. And I don't think people understand adequately about the economic, social, and cultural rights. I don't think, as I said, the legal profession adequately understands. Some of those cases, which were mentioned again, mostly by Dr. Miandazi, they're sort of single issue cases, and the lawyer picks on the idea that the Article 43 might help. But there's not an in-depth analysis of the issues, no clear understanding of the concepts of progressive realization, and of the 3 A's and a Q, the availability, accessibility, actually acceptability, and sometimes adaptability, as well as quality. We really need, we need to go sort of, in a sense, as a nation, to school about this rather complex issue. The judiciary has not fully understood it. They're getting better. The Mitchell-Bedell case, which Dr. Bhatia has just been talking about, was a very interesting one as a prospect for the future, because of its endorsement of the notion of the interdict in South Africa, we would call in really an injunction, planning for the future, telling the people, the parties concerned, go away, make some plans on this issue, come back and tell the court. This is what we need to be done on a much greater basis. So my time is coming to an end. I've just looked at my watch. So let me say, yes, it's not a situation without hope, but it does get rather depressing. Thank you very much.
Thank you, Dr. Jill Guy. I'll now open the floor to the audience. If you have any question, feel free to ask it in the Q&A sector. But in the meantime, I'll ask the questions that are there. And I have received 2 questions. The first one is from Evans, and he asks, is Kenya ripe for an equality and non-discrimination bill to address some of these issues? And what role will Katiba Institute play in that process? I'll give this question to Dr. Jill Guy, being the co-founder of the Katiba Institute.
Okay, but you know, the person you should really address it to is Victoria Miandazi, who has written an excellent book precisely on the subject of equality. But so I think she should also respond to this. Let me say, yes, I entirely agree. We do need legislation on equality. There are lots of complicated issues that arise, including the ones about how far in your private life you can discriminate, you know, which was sort of thing that will get partly sorted out in legislation. What part would Katiba Institute play in that? It's a very interesting question. We haven't, on the whole, been much concerned with the preparation of legislation. We tend to critique what's there rather, but we would be, although I did myself do a small book intended largely for the public service on this question, I'm sure it's something we would be interested in. But I would like really on that particular question, notwithstanding the flattering reference to Katiba Institute, like to know what Dr. Miandazi thinks about it.
Okay, to quickly jump on that, yes, the time is ripe. And as Dr. Jill Guy said, it's certainly high time. And also, okay, my book on equality and conceptualizing different interrelated conceptions is a good toolkit for that. So I'm happy if Katiba is willing to even just do a draft of what would an Equality Act look like. And it can also involve issues of substantive equality, because Article 25 of the Constitution I think it's B, subsection B, talks about the fact that socioeconomic rights, the delivery of socioeconomic rights, or fulfillment of socioeconomic rights should be prioritized such that those who are in most urgent need, or those who are characterized as vulnerable, should be the ones who, and are in dire need, should be prioritized. So that's basically a linking of equality, direct linking of equality and the provision of socioeconomic rights. So there's a lot that needs to be done, and particularly an act or legislation that has an inbuilt framework on implementation. So most of the laws on socioeconomic rights just talk about, administrative things, or just repeating what the Constitution says, but there is need to have an inbuilt framework on implementation and oversight. So that's all.
Thank you, Dr. Victoria and Dr. Jill, for answering the questions. I'll proceed to the next question, which has been directed to Mr. Ian Mathenge, and from Prof. Miiri. And the question is, how better can the court undertake a supervisory role in ensuring that the state has followed orders issued under Article 43, which ties in with a question asked by Nathan Kipchumba, that is, how can courts adopt a strong supervisory jurisdiction to ensure that their judgments in social economic rights litigations are complied with and implemented, especially in matters mental health? Welcome.
Let me begin by saying that those are two great questions, and they were subject to also a debate we had earlier on Me Too Bell. And my simple answer is this. First of all, as we discuss what the court can do, we must realize the limitations of courts generally, at least in the settings that we have currently. So, so that we also manage our expectations and we do not overpraise or we do not have unrealistic hopes as to how far the courts can go. Because some of these problems are structural and sometimes they require social change that can tend to be slow and so on. But having said that, the courts are not powerless. At least we have been able to see from South Africa jurisprudence and emerging jurisprudence, especially in transformative constitutions area. And I think also Justice, I think Mombi had done a very good job in Me Too Bell in providing for a structural interdict with an institution perhaps that is viewed as neutral, having the role of sort of acting as a third-party facilitator, speaking between the court and the government, and with timelines. I know there's also difficulties of that because of sometimes arguments with regards to scarce resources and so on. But I think that's a good starting point, so that at the end of the day, the minimum core, because I think that can deal mostly with the minimum core, but big structural issues, I think the court sometimes, the structural interdicts and supervisory role of the court can tend to be limited there, because the way we have conceptualized the role of the court. But having said that, the other thing that I wanted to note is that I don't think if there is any reason whatsoever on certain matters such as this that are dealing with human rights and structural issues, for the court to take an overly almost like an adversarial role. Or the court, for me, I think it can take almost an inquisitorial role. We have seen what has happened in Colombia with what they call the tutelas, whereby the judges become even so much involved in the implementation of the socio-economic and structural issues. I think Colombia is a good case study on the extent to which we can go with the structural interdicts through what they call the tutelas, if I'm not wrong. Yeah, I hope I have answered that question. Yeah, happy to take up any follow-up.
Thank you, Mr. Ian. There's also another question which I would like to direct to Dr. Gautam, and from the anonymous attendee, he asks, or she asks, what is the test for public participation in respect to implementation of socio-economic rights in the lens of international human rights obligations?
Yeah, so public participation in this context can come at two levels. One is public participation at the level of passing legislation. So passing legislation that seeks to implement socioeconomic rights. And the other is, of course, public participation in the context of executive action, which affects socioeconomic rights. So the first example, you of course have the Doctors for Life case in South Africa, which is the main classic case on the involvement of the public in the deliberations and the processes of legislatures and assemblies when they are passing bills that will affect certain specific sections, in that case, doctors, dentists, and so on. And the general principle is that you have to have certain markers. So there must be adequate time given to participate. You must provide access to the contents of the bill. You must actually go to those places and provide for those public consultations. And interestingly, two of the issues that have arisen in the Finance Act challenge, which has been argued the last 2 days, is that to what extent you have to give reasons if you reject suggestions coming from the public. And secondly, if you take those comments and then substantively amend the bill, what obligation is upon you? Of course, these apply to all laws, not just to socioeconomic legislation. They apply across the board. Now, in the context of executive action, which is where a lot of the action is, so there, the Mitubel case, and before that, actually, I think Satros Ayuma is the one with the clearest articulation of the principle. Justice Lanaola's judgment from 2013, it sort of articulates it most clearly, which is the obligation to meaningfully engage with the people that you are proposing to evict, if it is an evictions case, which in turn means that it's not just you give them information and then go ahead with the evictions. You must take on board and must demonstrate you've taken on board their inputs. So, for example, if the location you're planning to move them to is 40 miles away from the center of the city, where livelihood options are not available, if, for example, there is no disability access, things like that, and if that is pointed out to you as the authority, you must show that you have taken on board that when you decide what the alternative plan is. So meaningful engagement is central to public participation in these contexts. And the second is, and this comes from Latin American jurisprudence, taking on the Colombia theme, a lot of this occurs in the context not of individual evictions, which of course we've talked about, but in large-scale displacements, specifically of indigenous people, when you want to establish an extractive mining industry, in a particular area. Of course, in Kenya, you've had that same issue, and it's gone to the African court as well. So there, Latin American jurisprudence has this requirement of free, prior, and informed consultation. FPIC. Yeah. So the Ecuadorian and the Bolivian and the Colombian courts, have really discussed in some detail this requirement of free, prior, and informed consultation, and they have actually said that it's not just the state providing information about its plans and then going ahead. Again, you must actually show that you have meaningfully engaged with the objections people have. So, for example, if it's shown to you that if you want to build a pipeline through indigenous territory, and you are shown that, look, here is an equally effective route, equally cost-effective route, which doesn't go through this territory, and you still don't do that, then that's unconstitutional. So you have all these principles and requirements which in various ways try to ensure that public participation has some meaning in the socioeconomic rights cases, and it cannot be circumvented by the state, just by doing a pro forma exercise and then saying, okay, job done.
Thank you.
To quickly add on that, there's also
I'll now proceed
to quickly add on that, there's the aspect of meaningful participation. So in most of there should be an obligation to kind of give an overview, or to basically sensitize, maybe through info things in newspapers or stations. There is need to first inform people about what the proposals involve, and how their input would be helpful, so that it's not just about those who are knowledgeable or experts, but so to empower people with knowledge so that they can then critique that and say, oh, if that's the proposal, how does it really work? If it works like this, it would impact us negatively in this and that way. So participation also needs some element of education and sensitization to be meaningful.
Thank you, Dr. Victoria. And there's actually two questions that I'd like to direct to you. One that you have answered, but maybe you can expound on it. And that is from also an anonymous attendee who first said that it is great listening to these discussions, and asked, how do we have a balance between legitimacy of the government-led housing and economic rights initiative of the state, and lack of consumer-based and tailored approach that is acceptable and welcome guidance. Complete implementation, tax income, and smart prevention. Asked from the system, they has been very efficient in the implementation of social economics as Kenya from them. She's having the session and is learning a lot of things. So maybe Dr. can provide an answer back.
Okay, Ruth, you are breaking a bit, but I have captured the questions that you mentioned. So the first question that I've answered in the chat partly was about, the mismatch between, there are good initiatives, but in terms of their implementation, things go wrong. And we have a lot of that in Kenya. We have a lot of good intentions, a lot of, using Kenyan parlance, stories are jaba, as Kenyans say, a lot in the writing that appears so beautifully, flowery worded, but when it comes to implementation, there's a big problem. So I answered that and said that, particularly noting in the past months, what has been going on in relation to the targeting of civil society organizations that come out strongly to demand accountability, and basically fund initiatives that demand accountability, and these organizations being threatened with deregistration or their members being personally targeted. I said that it's always a good idea, going back to the collaborative approach, to not work on a silo mentality, but to work collaboratively. And for many organizations with the same mandate, or noting the issue of intersectionality with similar mandates in terms of the special interest groups or the issues that they're looking at, to come together and to come together and for the leaders to be, I find strength in quasi-governmental organizations that are set up from the Constitution. So again, going back to Human Rights and Equality Commissions, Office of the Ombudsperson, and there are so many other commissions, for instance, the one on cohesion and so on. So to collaborate and jointly organize to analyze these policies, to identify the gaps in these socioeconomic policies or legislations, or to even highlight burdens of inertia, because there's so much on inattentiveness, what is in the law, but there's a lot of silence. And so these gaps need to be identified. Going back to Jill's examples about, cholera, ailments that are not quickly treated. I'll go back to endometriosis, Jambi Kwekai's situation, and many others who suffer from endometriosis. There's need for medicines. There are no medicines. There's no infrastructure to deal with certain ailments. I myself have a chronic colon ailment, which basically is part of the reason why, I prefer, being where I am, because the medicines are available. They're not available in Kenya. What was available was something that, is for a worse off patient for that ailment, and would, mean me using steroids for the rest of my life if I went that route. So I was, in a better position to get those medications. But, we're talking about, as Jill said, evidence-based. There's a lot that can be done by these organizations to just bring the data and also identify the gaps. And then by banding together, they can also forefront or take forth these issues before, to make them a political agenda. And then, the strength in numbers would mean that if everyone is talking about this and organizing and having advocacy on this, then, it becomes a national conversation, which politicians would be helpless to ignore. And then I talked about the importance of participation, public participation, and as Gautam has explained, what would be meaningful participation. It would also mean some workshops, some community town hall meetings to sensitize people. And we're seeing that particularly in the fundings, in the university funding issues, because we are seeing that, if there are things that need planning, they're programmatic, that is, they're resource intensive. Obviously, courts are not enough. Obviously, as you can see from the university funding issue, courts have said that universities should not turn away students because of their inability to pay, even as we think about this new banding issue and the problems with it. But then at the end of the day, students wouldn't be able to sit for examinations without paying school fees. So the order is good, but then is it really effective? So, these organizations can be at the forefront in highlighting these issues, identifying the gaps, and coming up with proposals. Experts working with these entities and speaking with one voice can also be helpful. And if everything fails, going back to public interest litigation and banding together in public interest litigation is also very powerful. And as Ian has also mentioned, structural, and Jill also highlighted the importance of structural interdicts. And what I've been thinking about in terms of structural interdicts and how they can be effective, which also answers the second question about, in terms of implementation, what can be done? So structural interdicts coming at the end of the judgment are not as helpful as if they come at the very beginning or midway. There needs to be, strategies in terms of structural interdicts about what's the right time. And then looking at, combining that with the question about countries that, we can look up to where things have worked. Structural interdicts, which, looking back at South Africa and looking at the treatment action campaign case on the distribution of antiretroviral drugs all over the country, there was the setting up of, it was a structural interdict that also set up like a committee to look into things. So if these committees there's a way to come up with these committees, which was actually something suggested in the Mitubel case, but at the end, at the final judgment stage, I think it could have been helpful at the mid stage or at the beginning to come up with that committee that involves these state organs or agencies that are the ones that are supposed to implement these quasi-governmental institutions that have mandates on those particular issues, and also to involve civil society and also persons who are directly affected. So bringing these various stakeholders together in such cases can be really helpful if everything else fails, but also that public participation happening while these organizations are thinking about the gaps and proposals to have more evidence-based approaches would be really helpful. So this is something that I'm really thinking about, and I'm hoping that to take forward in terms of a book on, these strategies, and it needs to be contextual. Let's note that things are different in different countries. Right now, for instance, I'm now in Scotland, and we are having discussions, I've been a part of discussions about coming up with the socio-economic rights bill. But their problems are different, because it's more about, okay, we have right to education, but which type of curriculum would work? We're also handling things with curriculums, but it's more of like, we should let students have freedom at some point to be creative. You see, that's very elite, or that's a different, there's a spectrum, and that's like at the higher end of the spectrum, but we are dealing with so much, going back to the framework of the 3 A's and Q, so acceptability, affordability, availability, quality. We need to look at that and come up with a framework. And this doesn't involve just one person. It involves a collective. And so I hope, and also there's a role for the courts, as I've mentioned. So I hope that answers multiple questions. Thank you.
Thank you, Dr. Miandazi. Noting that we have 6 minutes before the concluding statement, allow me to ask a question that was asked by Mr. Sam Gure to Dr. Gautam, where he says, you have stated that the Supreme Court created a nascent link between sovereignty of the people and the right to housing for the landless of a public land. I read the mutable judgment as not trying to create a separate right to shelter, which the court stated was the right to housing in its base form, for the landless settled on public land, which was not a proprietary right to housing, but more of a right to procedural fairness in evictions and the provision of alternative sites of settlement without a corresponding provision of land. My reading of the judgment seems not to be as transformative as you. Would you agree, or if not, why do you see the more transformative aspects of mutable in relation to the right to housing? Maybe Dr. Gautam can also share the cases from Colombia, South Africa, and Latin America, as requested from an anonymous attendee. Yeah, thank you.
Yeah, so I'll email the citations to the Kabarak email address a little later. So on the question, so that's a great point, and I completely agree. I completely agree with you. What the Mitubel case did in terms of enforceable legal doctrine was to bring Kenyan jurisprudence broadly in line with the general sort of progressive global standard as exemplified in South Africa and so on, which of course is something that is well short of transformation. Because what it does is, in a certain sense, it humanizes the sharp edges of property law by making evictions more difficult to carry out. But it doesn't really question the very foundations upon which the current distribution of property rests. And so if you look at, if you symbolize evictions as a bulldozer, it throws some sand in the bulldozer's gear, so it doesn't stop the bulldozer, obviously. And in large part, that's to do with the many compromises that were made during the framing of the 2010 Constitution, which Professor Amrina Manji discusses in great detail in her wonderful book, and it explains why the provisions are, seem to be in a bit of a tension among themselves. So I agree with you on that point. I think where the radical or transformative possibility comes in is in the invocation of Article 61 by the court as the overarching framework that then is linked to the specific doctrines it lays out. And the reason why I say so is because when the court invokes Article 61 and effectively makes it enforceable through this set of somewhat limited standards, of course, it then follows that this principle should apply regardless of whether land is public or private, as defined elsewhere in the Constitution, because 61 does not make that distinction. And of course, as legal realists have taught us a long time ago, there is no inherent distinction between public and private land. The distinction itself is a creation of state legislation and the property regime. So insofar as the court interprets Article 61 to hold that every person has a legal interest in land, independent of legal title, the distinction between public and private land should not matter, and from that it then follows that even evictions from privately owned land must satisfy a certain substantive and procedural threshold. And in Musembi, the court goes some way towards that, but not very, very far. I think what Mitubel does is it raises open that possibility of actually saying, okay, constitutional norms must apply even in the case of private land, and it's up to future courts to really flesh out that in a transformative manner. So yeah, so in a sense, I agree with you, and I think that in addition to that, there is this underlying current of transformation that is now the responsibility of future courts to articulate, and of course future academics and lawyers to really flesh out in more detail.
Thank you, Dr. Gautam, for the response, for the feedback. And allow me to close the question and answer session because of time, but acknowledge the participation of Steve Musili and request him to ask the question maybe in the Q&A so that the panelists can maybe be able to answer. And also, there's a question that has been asked by Omemo Spinks on what steps can the state take in order to start the realization of economic rights. Maybe the panelists answer the concluding statements. So in that segment, the concluding segment, we begin with Dr. Victoria Miandazi, and we'll have Mr. Imatenge, followed by Dr. Gautam and Dr. Jill Guy. Welcome.
Sorry, Ruth, you were breaking a bit.
My apologies. When I was acknowledging, I wanted to acknowledge, I hope you can hear me. I wanted to acknowledge the participation of the audience and request that those with questions to still continue asking in the chat box and usher in the concluding statement segment, and which will begin with Dr. Victoria Miandazi.
Thank you, Ruth. So my concluding statement involves 3 points. So first of all, we started at a high with the constitutional provisions and then ended up being melancholic. And then ended up discussing about, and what I like saying, it's a cliche, but I really like this phrase, let's not agonize, but organize. So how can we organize? That should be our continued discussion. 5 years on avid readers, 14 years on socio-economic rights. How do we better organize? And then, so from this idea of organizing, going back to pinpointing, I liked, and I always insist from what Ian said, we need to move away from the adversarial approach to litigation and to thinking about particularly in relation to fundamental rights, to also to move to inquisitorial, for courts to ask the necessary questions, to ask for more information, to, like, for instance, in the Power case, where on provision of antiretroviral drugs that are generic, where Justice Mubigogi did her own research, brought in more, did more of an inquisitorial thing. And also there were, this amicus curiae are also very important in terms of highlighting issues. But then we shouldn't just focus on courts. As you said, socioeconomic rights, particularly in terms of duties to provide and fulfill, involve a lot of programs, resource issues that need policy making. So let's get involved and be active. So for instance, as I mentioned, there are burdens of inertia. There's a lot of inattentiveness. Many things are ignored in the sidelines and forgotten. So we need to, as academics, as civil society, as individual citizens, what can we do? How do we better organize, not just in courts, but also there's someone who also mentioned mediation and alternative dispute resolution. As I mentioned, this, for instance, National Equality and Human Rights Commissions have been good at that, but how can we better do that for socioeconomic rights? So thinking outside of the box, thinking outside courts, how can we help in terms of coming up with new legislation, better policies, commenting on what is being done, and making our voice heard, and pushing for amendments and better proposals. And then lastly, it's all about, what can be also the role of, I thought about role of AI. So it's not only trendy, but I've been thinking a lot about this in relation to corruption. So going back to the Kefa Omondi Onjuro case, where, it was about the houses that were being built and given to people from Kibera. So it was a joint government World Bank project, and there was a lot of people were complaining that politicians had allocated themselves houses. So I think in terms of, having reporting mechanisms and finding out who is actually benefiting, AI can be helpful in this evidence-based data collection. So that's all from me. Thank you.
Jumping into it, thank you, Victoria, and thank you, Dr. Gautam and Dr. Jill, for the great presentation. It was a pleasure to be with you. My closing remarks are that we have a new dawn, and the new dawn is the Constitution 2010. I think the extent and the promise of the Constitution 2010 has not yet been fully realized or tested. And today, just randomly, I was looking at Article 25B, and which says that in allocating resources, the state shall give priority to ensuring the widest possible enjoyment of fundamental rights. So I was trying to look at this vis-a-vis what has been going on with the budget discussions that have taken center stage and have been mainstreamed. And everyone is involved in budgeting process, everyone is aware. And I was asking myself, how many MPs, for example, look at such a provision or think about human rights as an end goal to budgeting, or at least have human rights even at the back of their mind when they are budgeting. So I think that the Constitution of Kenya presents a big or a huge promise that has not yet been realized, and it can only be realized if the citizens become more and more educated. So that here comes the role of public education or sensitization on human rights, because as we have seen with the Gen Z revolution, generally the power of the people is more stronger sometimes and can be even more effective than even the court system. Not to replace the court system, but they should speak to each other and complement each other. Because currently, as we speak, Parliament seems to be dead. It has been captured by the executive. The executive itself seems to be quite parochial in implementation of these policies. So we are left with the people, the primordial power of the people, and the courts. So my part in short is that let's empower those two institutions, and slowly you'll find that even Parliament, coming maybe perhaps in the next election because of this kind of education, we'll have a Parliament that is more independent, as that people can trust more and more. And lastly, is that generally thinking about human rights, one might think that we are talking about very abstract things. But today, you saw what has happened in the airport because of this Adani debacle that's going on in Kenya. And I would say that if, for example, this project was to be implemented, taking human rights approach, as we say, the participation of the people would have been a core principle that is embedded in the project. Accountability, non-discrimination, empowerment of the people would have been at the core. But all that we have decided, and the way the government seems to be proceeding, is at the end that justifies the means. everyone else is a stumbling block to realizing that goal, which goal we cannot be able to say as we stand is anything altruistic or anything egalitarian. It seems to be parochial and individualistic to certain people by all measures, going by what that PPP agreement. So, and perhaps the other point we should integrate as people think about human rights and governance and policy is right now we are being faced with governments that have scarce resources. So the role of PPP is very attractive. But as PPPs are becoming very attractive, we must be worried of the effect of PPP and the potential capture of PPP. That's something that we ought to think, because just because something is PPP, it's a private partnership, and it's coming to bridge that gap, the resource gap, does not mean necessarily it was to be implemented without the necessary accountability mechanism. So that would be my parting shot.
Yeah, just say two things. I think just leading on from what's been said. One is that all constitutions are terrains of struggle, and they all have within them competing visions of power. A more centralizing, a more statist vision, as well as a more egalitarian, and a more progressive vision. I think one role that we all have to play is to try and advance that second vision in these moments of contestations, both in court and outside court. And the Mitubal case is an example of those two sets of ideas of power being in tension, and the court navigating through them. And of course, discussions like this and the Avid Readers Forum does a great job of taking that forward. So that's one thing. And the second is that these struggles and something taking on from what Ian just said are all linked. So the more top-heavy centralized structure of powers that a constitution has or facilitates, the less likely it will be that you will have genuine socioeconomic rights implementation. Because the more you centralize power, the less reason that power has to accede to popular demands. So in that sense, the struggle for Article 43 implementation and socioeconomic rights is linked to the parallel struggle for democratizing political power. And that I think that those linkages is something we should always remember, as we give shape to struggles and find those commonalities between them. So I'll stop with that, and thanks once again for inviting me, as always.
Okay, interesting. I think that we're all sort of thinking on rather similar lines. We're all thinking about empowering people. So maybe we're all getting fed up with even with courts and certainly with government. And my comments are rather on the same lines. My first one was about just wondering about this issue, like my problem about the poor kid who died of cholera. Could something be done more, and how would it be done? And the judiciary could help to make sure that every section of the government and other people as well, whose duties have been spelled out in court cases, actually know what their responsibilities are. How, what is the communication chain? The second point is the role of civil society. We as civil society organizations, I think we need to do two things as far as litigation is concerned. And sometimes I'm a bit tempted to say litigation isn't just achieving it, but litigation is important, but we can make it more important and more effective. One thing I think is that we need maybe more specialized civil society organizations that will pursue particular issues. I think in South Africa, there's more of that going on, as with the TAC case and with the cases on education. So they will take a case and then they will be pursuing other cases on similar lines. So it's not, cases are not isolated. And then having got a judgment, I'm not sure we're very good always at actually pursuing. We don't always appeal when actually there's an appealable case. We're not always very good at pursuing issues of contempt of court. We need to make sure that cases have their maximum impact, including informing people. And my final point is the ultimate sort of citizen involvement would be, how can I put it, citizen monitors, right? thinking about the recent terrible fire tragedy, and indeed others have been going on, there have been stories about parents who say, when we go to look at a school, we're not even allowed to look at the dormitories. That needs to be dealt with. But also parents and other people, they need to be able to go around. Does this school have the required fire precautions? If not, I'm not going to send my child there. But they need to know what those precautions are. And we can do this. And I know there is a problem. There is what's called a public participation fatigue, if you like. You can't get, but I do think perhaps we could involve, or people could be organized to be more involved in taking some sort of responsibility for the constitution, which is ultimately for them as the sovereign people of Kenya. And when, a bit depressingly, the official organizations, which are supposed to be monitoring things, are so dismal at doing it. I've just finished my weekly column for the Star. And I've been talking about Senator Mungatana's bill on religious organizations. And one of the things that struck me is and this is also made in another article recently, our tendency constantly to set up organizations to do things, a new authority, but we don't have the money. You're asking people to do more and more. They're not even doing what they're supposed to do now. We think we achieve things by passing laws and setting up organizations. And dismally, much of the time, we do not. So some of these things, we do need some fairly radical rethinking, I think. Thank you very much to the organizers and to the fellow participants, a real pleasure.
Thank you so much, Dr. Jill. And thank you so much to the other panelists. And one recurring question that we usually have in the Avid Readers Forum is, what is the importance of having these conversations? Because this, for example, social economic needs, they're not merely abstract needs, but they are real needs in the society, and therefore what's the importance? And I think what Dr. Jill has touched on, that it is important because through these conversations we can empower people, and maybe even the audience, we have someone who will be part of the executive, and they will remember the importance of implementing and providing social economic rights. And therefore, thank you, dear panelists, for honoring our invites today to have this essential conversation. Great thanks to Dr. Jill Guy, to Dr. Victoria Miandazi, Mr. Ian Muiti, and Dr. Gautam Bhatia. We really appreciate your presence. You have made this conversation really enjoyable. And I also would like to thank the audience for participating, for listening in, and for asking questions. We really appreciate you. Allow me to also thank the organizers, which was the Avid Readers Forum, and it comprised of various individuals, including, allow me to mention a few: Marion Joy, Sylvia Nyanchama, Sadiq Kadima. We have our convener, Mr. Elisha Ongoya, and also someone who has helped us with setting up the meeting, Mr. Gekome, and also Mr. Karo, who helped with making the posters. Thank you so much for taking up your time to help make these conversations come to life. And also like to thank God for the day and for giving us this opportunity to just have this conversation. So I'll also like to invite you guys to preceding conversations, since this conversation is actually a bit Avid Readers Forum turning 5, and therefore we promise that you will have a good time, you learn a lot, and you will enjoy. So thank you. We have upcoming sessions. We have 2 more upcoming sessions, and they'll be on Wednesday. So for the audience, you're all welcome, and yes, God bless you. Goodbye for now. Bye.